Hello, welcome again. Today, what I've done is that I helped a friend of mine to amend his joint venture agreement. Right. Um, I have redacted the personal details, but I want to go through this. For those who are interested in doing a joint venture agreement, a joint venture agreement normally in this case is where the owners have a piece of land. I mean, it has to be available land, and the other party is a property developer who doesn't have the land but have a lot of money. Well, supposed to have a lot of money. And I'm going to go through the steps that you should look at when you're if you're doing it yourself for a joint venture agreement. Of course, this is not legal advice. This is just giving you tips on how to look at the issues. uh, so in this case, the land is agricultural land. So the developer will have to convert that to a development land. Uh, this this particular piece of land is unique because they have actually five different owners, and I think two of them was uh, children of deceased. I mean, like grandfather gave the five sons um, the piece of land, and then two of the sons have passed away. The grandfather, of course, have passed away, and then the children of these two obtained probate. So they have to um, get all these things done first, right? I mean, so that's why this is the part which they have to. I mean, if you have all these problems, I wouldn't say problems. I mean, these are things that you have to be careful. So in this case, you have to get all those documents ready. I mean, otherwise it doesn't work. So this is what they were talking about: obtaining court orders, registrations of power of attorney one and power of attorney two. In this case, there is two power of attorney, and I'll explain why there's two. First of all, the I don't have the power of attorney with me. This is just the JVA. Power attorney one deals with the authorities to get uh, what is it? The developers authorities, development authorities. Like, for example, going to the council's office and putting in the plans and the subdivisions and so on. And power attorney number two is basically to sign all the sales and purchase documents on behalf of the owner. Excuse me. Generally, I would not encourage people to give any power of attorney. Um, yeah, I mean, because whatever things that they need this power of attorney for, it can actually be done. It can actually be done by the owners themselves. And if you give them this power of attorney, then what happens is that they will not involve you in the loop. I mean, like, you don't know what's happening. I mean, for a project like this, it can go on for 4 years, 5 years. You don't have information. Once you sign a power of attorney, you cannot even go to the council anymore and say, I want to know what's happening with this project that is running on your land, because the council say, I'm sorry, you have given a power of attorney to developer, so I cannot talk to you anymore. So that's very so even if you want to give a power of attorney, make sure you give a very limited one where you always be consulted, right? Okay, let's look at the nitty gritty, right? So in this case, they want the owners to undertake to fulfill preconditions. All the preconditions, that means getting all the orders and so on, right? Probate orders and so on within 6 months, and that makes it unconditional. and they're gonna give $300,000 as security deposits, right? And right, so and they're gonna pay another 52,000 as ex gratia payment, right? Anyway, this 300,000 thing is security, right? So if something happened, if something doesn't go through, they have to refund this. Not the fault of the developer. They have to refund this money. That's quite obvious. I mean, that's what security deposit is about. Uh, okay. Shall be paid to the owner, solicitor, and stakeholder who are authorized to release. So they give the money to the lawyers first, and then they authorize to release the sum once this agreement become unconditional. Um, so they want a vacant possession of the land once they give you the, once you receive a 1 month, well, I mean 1 month after the written notice is given. Uh, so that's okay. So this is the part, because for development you need to get development approvals. Uh, they want themselves. I mean, they wanted to get it within 30 months. That's a long time. From the unconditional date. I suppose this 30 months takes into account the current situation where you have COVID, where all the government departments is running half, not even half. Sometimes it's just skeleton staff. So it could be this reason. I don't know, but they put it in. So they have to employ a surveyor and lay out a plan, and then apply for the preparation of plans, building plans, and so on, conversion and subdivision as well. So all this takes time, especially for subdivision. It takes time. Um, I mean, there are some projects which have subdivisions that's been going on for donkey years. It's never been a, they never got through it because it's just because probably it's worth you know why, because sometimes the developers have more control of the because if you have your individual lots, then you do not need to use the developers to transfer the assets for you, the lots for you, as long as your lot still is in the master uh, uh, title, then you have to ask the developer to help you, and so on. So so those are not big deals, right? Okay. um, I know what happened. um, I just managed to see that I forgot to put in the markups, right? I actually done the markups, but um, it just didn't show up. Anyway, so this part here, I added this words provided always subject to mutual written agreement by both parties. So sometimes, I mean, you have to change the plans, whatever changes that you have with. I mean, the developer have to tell you. If it doesn't tell you and he make all kind of funny changes, then it's too late. So I put in this part here, which he has to come back to you. When the plan vary or amend to comply with requirements of the appropriate authorities. Um, the reason is because sometimes the authorities may want a larger road, a bigger road or whatever. They want a park inside the development and so on. So because you have fixed land, and if they insist on a big park, right, then you have problems. Then all the things have to be shifted around, and you may get a very different deal than you started with. Okay. So I added this part here. I mean, it's just that it's important for the owners. As owners, you are kept informed of the progress each month or each month. Seriously, I mean, if you don't have that, then I mean, this is just to put in so that you can ask for it. Normally, the developer, once you sign everything, they don't really care about you, which is wrong. All right, we come to the powers of attorney. Um, like I said, you know, if you, I mean, power of attorney is a must for all JVA. I don't know why. I mean, I wouldn't give them any power of attorney. But if they really want one, then it'll be so limited that it's just pointless. But anyway, this I'm not actually writing the JVA for my. I mean, I'm not writing the JVA. I'm just trying to balance this JVA. This JVA was written by another law firm, nothing to do with me. So happens that my friend asked me to look at it, and I think, I mean, because I do litigation, So I understand all the stuff that we need to put in from just in case. I mean, you have to make your so-called JVA as strong as possible. So in this case, I put the word lawful matters. So for example, the reason why I put that is because anything that's not lawful, you don't have to uh, say, for example, because the power of attorney is between a donor and a donee. So I'm the donor. I give you power to do things for me. But if you do unlawful things, say for example, you rape a girl, or you steal money from people, right? I mean, even though I mean, I'm not saying you. I mean, don't steal money. Say steal land. Steal land or do whatever naughty things. Those are unlawful things. So I don't have to. I would not agree to give you power to do that. So I will not endorse those matters, right? Because in the power of attorney, there's a clause that says that I mean, we will only endorse or confirm those lawful acts or matters. If it's not lawful, we don't have to. I mean, this is the point you can always argue in court. I never, even though the power of attorney is drafted very wide, I mean, sometimes you can see it's so wide that it's almost, I mean, some lawyers went overboard. But as long as it's unlawful, you can still pull it in. So you just you don't you will not what's the word? Sorry, this is from another of my old cases. Just want to point out to you that the correct word is ratify. So we don't have to ratify anything that is unlawful. So in this power of attorney, which is from another case, not the one that we're looking at now, I pointed very clearly that we will only ratify and confirm all that our attorney shall lawfully do or cause to be done by virtue of this deed. Right? So that's the word ratify. I forgot about it. Sorry. So power of attorney again is very important, and I put down here that the developer are entitled to do whatever they want only after they have notified the owners of the matter. So what I put a restriction here, a precondition that if you want whatever things you want to do in my name, please notify me first. And I don't have any objection, then you can go ahead and do it. Right? Normally they don't, they just go ahead and do it. So this is wrong. So I put it very clearly here. So if it's not in the JVA, it will be in the power of attorney. So this is very important as well. You have to be notified. And of course, the power of attorney will be subjected to this, as long as this JVA is in force, the power of attorney will continue to have effect. Uh, so that I mean, so very very important again in the power of attorney, you don't give what we call irrevocable things. Never give people irrevocable. You see the word irrevocable, just delete it. No need to think, just delete it. And and never give a power of attorney to facilitate a loan or charge or whatever for said purchases. uh, see, the banks will always want. See, the banks, when people buy properties from your land, I mean, they expect that there will be a, some sort of house or building there in a couple of years' time. Like in this case, will be 4 years. I'll tell you later why. But what happened is there is no property. I mean, sorry, no house there. The developer has run away, right? So the bank will always want the land to be collateral. If it is not collateral, they will want the landowner, because the landowner have a valuable assets. The developer doesn't have anything. He has nothing except, you know, maybe some cash. Most of them have nothing. They use other people's money to build property and make a lot of money from you. So you got to remember that you don't have to give them any assistance. In fact, you are the one that need assistance. So you got to be very careful. Never let them charge your land, or somehow another way they do is that they sell among themselves. So the property developer will sell that off the plan to his friend at a very high price, and then the bank, and then when, because there's no title yet, right? So the assignment, the purchaser will assign all the rights to the bank. That means your land, everything for the lot of land will be assigned to the bank. So you have to stop that. You have to prevent them from selling anything off the plan, right? Those is very important. So as I was explaining just now, they want a PA one, and then a second PA to sign a memorandum of transfer, sale and purchase agreement, and any relevant documents for building development lot. So the PA two, they separate two documents, right? One is for the authorities approval, to get all your building plans and so on. And the second one is to to sell stuff, to sell the lots on your land. Remember, the property developer hasn't bring anything to the table yet. Has brought nothing, right? And here he is selling your lots. He's selling the lots. Once the plan is drawn, the plan for the lots are drawn, technically he can sell it, but you have to stop this. So in my case, what I've done is that I said the PA shall be released. I mean, like the PA shall forward it. I mean, you sign the PA and it's forwarded to your solicitor, to the developer solicitor, and shall be released by the from the owners to the developer upon the issuance of certificate of practical completion only. So you see, what they have done here is that they put the individual documents of title of said land. So so what they have done is that uh, they wanted to have the power of attorney to sell once the individual document titles of the land has been issued. To me, that is not fair. That's not fair because the developer have done nothing up to that stage except applying for subdivisions. So it's I mean, the property developer, sorry, the landowners can do that themselves. They don't have to. Uh, they don't have to. No, there is no. It's not good. So you should only give them the power to sell once they issue the certificate of practical completion. Certificate of practical completion ensures that the project is almost complete. Then they earn their keeps, so to speak. And this says that the developer will get 70%, and the owner will get 30%. Again, I put everything, even titles, attaching. They have to attach a certificate of practical completion, and so on and so forth. Uh, the owners doesn't have to consult with the developer. That doesn't make sense. The owners can select the property lots first by signing on the layout plan, and that's it. So because the owners have the first right to choose, you always have the first right to choose, and the balance goes to the developers, right? So you don't have to consult. There's no reason for you to consult because the developer has no choice, right? So consultation doesn't mean nothing. And the other thing you should remember is that for the selling price, it has to be mutually agreed. If you don't, I mean, like for example, the developer have to have a selling price fixed. They cannot change the price as they want. So, but if you don't know the price or you don't agree with the price, then you have a choice now to get that in black and white, right? And they talk about this CPC later, but no, no, no. You must get the CPC first. That's the way I look at it. Uh, right. And this part here, again, I stress the part that the developer entitlement shall be released to the developer or developers upon issuance of certificate of practical completion or certificate of completion and compliance. In West Malaysia, they use CCC, and in I think in most countries we still use certificate of practical completion. It's the same document. It's not what we call a certificate of stage or work done. There are case law that says there's a difference between the two, which is very, very important. And make sure you spell this word out because this is a word. Certificate of practical completion is a word they use in the construction industry. Don't put anything else. So what they want to say is that to issue the title should be released to them once the construction project has reached 75%. The reason why I didn't want this is because reaching 75% uh, so allows them to sell. So in this case, uh, they want to be able to execute the sales and purchase agreement of the remaining individual titles of the unsold uh, development units once construction of the project reaches 75%. I wouldn't encourage that because 75% does not mean the project is completed. If it, I mean, like if they reach 75% and then they sold everything, but they don't complete the project, then you will have some issue later. So it's always important to get the. I mean, there is no reason for them to just stop at 75%. I'm not saying they will stop at 75%, but I'm saying it's just like it's safer to get the certificate of practical completion. In fact, in most cases, they are still getting money from the bank. If if they have sold their, I mean, like I was saying to you, they probably can't sell it to everybody. The developers actually sell maybe about 25 to 30% of the entitlements first, just to get enough money from the banks to start the project to go. I mean, this is the modus operandi. They know they can't sell everything, and because unless it's a very attractive development and a very very good price, and normally they just sell to the relative and friends, just at a lower price, and then once the project is finished, uh, they will just sell it at a higher price in the secondary market. This one, after the conversions and issuance of title into, blah blah. Again, I introduced this part here: issuance of certificate of practical completion. Right, it's safer for you, and yeah. So it's a bit confusing. So I don't. I mean, to me, they're causing themselves to be confused because they're talking about remaining units selected by developer erected on state land shall belong to the developer. I mean, we know that transferred by to the purchasers. So technically, they are not entitled to those units of properties until it, in the original case, when reach 75% of construction, because you cannot sell what you don't have, right? You can only sell when you have something. So it's better to keep to this consistently to have the CPC then you sell. This one here, develop. Yeah, I mean I'm just wondering that they should have the developer license should be obtained first, or none of this can happen. Uh, well, in this particular case, which is very unique, they actually set up a $1 company to be the developer. I don't know why. I wasn't. I'm not privy to the entire thing. So they're just saying that. So when you have a $1 company, I don't think you will able to apply for a developer license because they need certain pay up capital. I mean, otherwise, every Tom, Dick, and Harry will be applying for a developer's license, right? Uh, so far, there's not much changes. Um, right. Okay, of course, the owners will bear the quick rent and assessments respect of the entitlement upon delivery. So once they deliver, we will, I mean, the owners will pay for that. And these are the representations that are undertaken by the owners. Um, I put this one here. Any lawful conditions that may be imposed by the proper authority, blah. And the reason why I put this word lawful again is because uh, sometimes people forget. I mean, like for example, councils. Local councils are the authority that has the power to approve property developments. But I noticed in some cases the local authority use their power to approve your development as a bargaining tool to get something else from you. What are the things they want from you, right? Okay, for example, because town planners, they want to they want to get. I mean, they want to make the city much more livable, so they have a lot of plans. And one of the plans they have is that they may want to include a cycling lane, right? Cycling lane or parking, car parks, or whatever. And if they find out you have a huge piece of land and then you only allocated maybe a quarter of it for this development, they may ask you to yield some land, right, for public purposes. On private land, they may ask you to yield. I mean, it's something that you have to remember. They don't have the power to do that. It's a bargaining thing. So normally governments they have to use the land acquisition ordinance to acquire land. But this is another way they would do. For example, I mean they can delay your development by just not approving it and taking their own sweet time. That kind of thing I'm talking about. So in this case, what I'm saying is that the landowners they will accept any lawful conditions, right? So it's not lawful. Like for example, if the local council asks them to give up part of the land for a children's playground, then it's not lawful. So they can never accept that, right? Um so this part I don't really understand. Okay. So anyway, I have no idea. So you might have to read a bit more about all these rules here. I don't have the time. But what I can understand from this G is that they want you to be aware of this, right? So it has to be something that it has to be to do with sale. You know what they're saying is that the developer may, in his own name, enter into contracts of sale of any of his own lots and building to be erected thereon until such lots are transferred to the developer or his nominee. So what it means is that they are allowed to so they allow developer to sell to himself or his nominees, right? In strict compliance. So they say this is in strict compliance, blah blah. Like I was saying to you, one of the tricks they use is that they once there's a sales and purchase, they need to have a sales and purchase in order to get a loan. So technically, you can set up a developers company and you can set up a number of $1 company and having the same directors as the developer and then sell to themselves. That's the normal thing they use to in order to refinance themselves. So, but anyway, like I say, it's better to read these things up. Um, okay, that's it. Again, like I was emphasizing again, the owners hereby agree that they shall allow the purchasers of the developer's unit to charge the unit's purchase to a bank or financial institution in order to assist the purchasers to complete a purchase. I mean, yeah. So they make it very clear in most cases when people buy a unit, they will need a loan, and then the bank will need a charge. But what I'm saying is that provided always that the individual title has been issued with attached certificate of practical completion, and the owners have been notified by the bank or uh, sorry, not of or oh shit or financial institution. So what is the reason why I say this is because I have a case now that the unscrupulous property developer, uh, using his power of attorney, have decided to tell the bank to give an undertaking on behalf of the owners that if the purchasers are unable to pay the loans, then they can take the land or they can claim from the landowners the entire loan. I think that's a bit ridiculous. I mean, like, I don't even know that the landowners themselves now are obligated to pay the bank for somebody else default. So it's very dangerous. You should be careful. Like I said, you should be careful with the power of attorney. That's where all the problem comes in, especially with unscrupulous developers. Um, so developers can be, big developers and small developers. It doesn't matter. They are there to make a lot of money at somebody's expense. Usually the landowner. So again, like I say, ask for the issuance of certificate of practical completion, and all the time. To me, it's all the time. You see, so in this case, right, what they want is that the developer shall have the right title and registrable interest by virtue of this agreement is not okay to me, because by virtue of this agreement, you have not done anything yet. So until you have done something, so this is what I added, and it is hereby agreed after, okay, after the issuance of certificate of practical completion and individual title, two things together. That means the building is completed and the individual titles, then you have the right title, has the right title here, of course, and registrable interest, and so on and so forth. Right. Again, this one is I um, I wanted to, because this is a very special case where they included a brand new company they just created about a week ago. So I say it's a $1 company. You better make sure they have some pay up capital, not just you know sh- share capital, like number of shares. It's actually pay up. Pay up means they have to put the money in the bank account. right? So I also make it very, very sure that they cannot charge mortgage or use any of the security for any loans or to encumber the land in any manner whatsoever. Otherwise, it's a violation of this agreement, resulting in effective termination without notice. So I want to make very clear that they can't do anything. If we know they've done something wrong, such as getting a loan, and that's it, the whole contract goes off. Right. Yeah, this is quite common. The cost, everything is the cost, right? So the developer cost only comes in. Uh, so this is the cost they have to put up. I mean, like for example, they have to hire architects and so on. Defect liability is 24 months, but normally there's a law that governs this. So there's nothing for you to worry. So completion of the project. So they are talking about certificate of completion and compliance or equivalent certificate issued by the relevant authority. So I took this out because uh, it can be very confusing, right? So you better not kid yourself. If they get a bogus certificate or some sort of certificate which you don't even understand, most people don't even understand what it means, and they argue that it's equivalent, then you'll be in trouble, right? So remove this straight away. I mean, like I said, the word certificate of completion and compliance is used in West Malaysia. In other parts of the world, we still use certificate of practical completion. This is for delay. So I suspect that it's 7,500 for each lot. I think they should put the word each there to make sure. Yeah. So we can extend it again if we have reached the milestone 75%. And termination is it's developer wholly suspend any activity is continuous for 6 months, right? So they were talking about construction works, but it can be, I mean, they don't have to. I mean, if you just focus yourself on construction works, then it could be, uh, you know, go long. I mean, anything that stops for 6 months, you're finished in this case. Same here. Um, so I mean, sometimes I don't really know because when I look at clause 9A here above, there is no time frame. So I don't know why they put it there anyway. So this may be just a bit of a typo or slip up because this is still a work in progress JVA. It's not even, I mean, it's just the first draft. So we make it final that if the developer breach any of these obligations undertaking in this agreement and unable to cure the fault within 6 months upon request by the landowners. So so we make sure cover your base. Anything else that they have breached and they cannot cure, 6 months you're gone, right? So this is the government acquisition thing. Uh, I don't know why they have 33% for development 67. I mean, like I say, um, I mean, when the government acquire your land, it's nothing to do with the developer. So I don't know why they're here. They probably the project has to be stopped. Once the government acquire a land, the whole thing goes off, and maybe they're talking about such certain expenses they have incurred up to that time. But normally, government doesn't just take your land because they have to pay for it. This clause 16, Simon, is interesting. A JVA is basically a contract between two parties who wants to work together. I mean, it's if you think about it, it's like a marriage, right? It takes time for you to find your soulmate. So, or in this case, working mate. I mean, there are lots of developers out there, and it's very, very difficult to, to distinguish who are, I mean, who are the real McCoy, or just, anyway. What I put here is that, I mean, it says that they have the right to assign this JVA to a third party if they want, and they can obtain the consent, and then consent must not be unreasonably withheld. So I will add one more line. It says that unless the assignment is commercial and the developer stands to gain or profit at the expense of the owners. So that means you have purposely come in, because actually, like I was saying to you, when the developer doesn't use any money other than legal fees to come up with this agreement. So he signs it with you, pay you a security deposit of 300,000, and then he flip it to another bigger property developer for a couple of millions. So that is then I would say you withhold your consent, because it's not to your it's at your expense, right? Because you spend so much time going through all this, JVA thing with this, this so-called developer, and then he flip you to a bigger developer who pay him a lot more money, and then the bigger developer will come in, and then they will again, modify the document, the agreement, and so on and so forth. So so there'll be never ending, right? So it's a waste of time, and so on and so forth. Outgoings, tax liabilities, blah. So this no partnership again. That means, a JVA is two separate entity, right? No partnership. These are quite common: cost fees, and bore by stamp duty and so on. Stamp duty is required. Okay, registration. This waiver. I mean, these are basic stuff, right? This one as well. Notice, right? Modifications or variations have to be shall be valid unless made in writing. Right? Okay. I mean, it's always you need to be in writing. Excuse me. Right. This is an interesting one. Mutual trust. A mutual trust clause is, you always find it in the JVA. I don't know why though, but because in the JVA, you will come to. I mean, the whole JVA is, you cannot put everything inside. You cannot, I mean, foresee all the possibilities, right? For example, in this JVA, there is no force majeure, acts of God. So I included that. I mean, a force majeure clause can be very can be quite tedious. But anyway, they don't have that. So I put everything here under this mutual trust. So what they're saying is that the two parties must trust each other, that they're working together for a common benefit. I mean, that's what a joint venture is about. But of course, in a joint venture, there will be time when there will be a conflict of interest. For example, the developer may see something, and because he's in the business of selling stuff, selling properties, so he may act against the interests of the landowners without the landowners knowing. So what they say to me is that, I mean, unless you know you have been screwed, you are not screwed, which is the thing. So I put here to avoid conflict of interest. The developer must always act in good faith with the owners and not for its own benefit without informing the owners. So I think that clears up the the role of the developer, that you always must act in good faith, because the landowners themselves are not sophisticated enough. So they must always act in good faith. And if there's, you know, to avoid conflict of interest, and you have to inform the owners if there's a conflict of interest. All right. So yeah. So that's what I put in. And arbitration clause is up to the parties. Arbitration now is common. It's quite common in most agreements. Once you have arbitration, uh, I haven't looked at this. I mean, this is a very generic clause, but there are certain clauses that says that you have to go to arbitration first, right? And this one doesn't say that. It says that anything related to this, any disputes, difference, or questions, right, between the parties, uh, shall be referred to a single arbitrator. Blah blah blah. Oh, appointed. um, but there are also certain clause that says that it's what we call. Just a minute. I'll just try to remember that clause. Just one. Yes, I'm sorry. I just wanted to bring the attention to, for example, this particular clause, right? So this one is slightly different. It says a party must not commence court proceedings in respect of a dispute arising out of disagreement. So this is one of the clause that prevents you from going to court unless unless you have done the this anything by not commence in respect of a dispute out of this cause regarding a breach of purported previous matter concerning parties' performance and the termination of party rights. So this kind of clause stops you from going to court. So what I want to point out is that an arbitration clause by itself refers you um, to go to an arbitrator. Say, for example, this one, right? You know, what they're saying is that anything in respect coming up from this agreement shall be referred to a single arbitrator. But it does not say you cannot go to court. So such arbitration clause, if you want to make it stick, you should have something in front that says, you know, um, you have to do arbitration first or something like that, which this one doesn't have. But remember, I was looking at the remember this one. It explicitly says that you cannot commence court proceedings. So these are the pertinent language, shall we say, that they draft to make sure that you go to arbitration first. Okay. Okay. So other things is quite binding effect, time of essence. Right. Okay. I put in some other stuff like final agreement. That means everything that you see in this document is what you see. You know, anything prior doesn't help you. You should put that in. And it's non-merger. That means even though this agreement finish, anything that hasn't been fulfilled will continue to run. And entire agreement means that the that's our understanding of everything. We have not left anything out. So these are general stuff that should be in, which is not in this, right? And the that's it. That's it. We finished. Thank you.